Good morning. On behalf of Judges Redford and Rick, I want to welcome you to this session of the Court of Appeals. As you know, we've had an opportunity to read your briefs, plus we had a internal memo outlining all the arguments. And so we're very familiar with the issues and the facts. So please take that into consideration when making your arguments. And the extent any of these criminal cases today have any minors involved, please do not use their names since these arguments are broadcast on the internet. With that, I'll jump into the cases. Item number 14, consolidated cases, docket number 370396, 370397, People versus Cortez. Only defense counsel is endorsed. Good morning.
Good morning, Your Honors. May it please the court, John Zevel King on behalf of Mr. Omar Cortez, and thanks for hearing his case this morning. I've argued a couple of items about lifetime electronic monitoring. I'll rely wholly on the briefs for those, but I would like to address the ineffective assistance counsel claim. And with your indulgence, I will begin with a homey analogy. And that is, I offer you 2 jars of spaghetti sauce for sale. And they're different sauces, but they're in the same size jars. And I tell you that one is $5 and the other is $10. And I ask you what you would like to purchase. And you say, well, what's the difference? And I say, well, one's 5 and one's 10. How can you make a choice on which spaghetti sauce to buy if you know nothing about the quality of the sauce, but only the price? And by way of homey analogy, that's what happened to Mr. Cortez during the plea proceedings in this case. Throughout the evidentiary hearing, trial counsel, defense counsel testified that he focused on the penalties during the plea proceedings discussions, not on the potential for success of the case, not on potential strategies of the case. For example, when trial counsel was asked if he ever advised Mr. Cortez of his chances at trial, trial counsel stated, and I quote, "My job is to have him weigh the risk of going to trial penalty-wise versus taking the plea." Now, trial counsel, and that's page 8 in the evidentiary hearing, trial counsel also stated every attorney can assess the strengths and weaknesses of a case. That's pages 11 and 12. But trial counsel could not recall any strategies that he discussed with Mr. Cortez during the plea proceedings. He could not recall any discussion about the strength of the case during the plea proceedings. Mr. Cortez also could not recall any discussion about the strength of the case during plea proceedings, except something about 50-50. And he could not recall anything about the strategies of the case, except for something about inconsistent statements.
Yeah, I thought that your client testified that that his counsel told him that it was a 50-50
Yes.
on trial.
Yes.
Isn't that generally what we all say? 50-50 on your...
Your Honor,
You don't know what the jury's going to do.
well, so let's say we keep telling them, hey, it's fine. It's 7 to 25 years. It's 7 to 25 years. Think about that. But we don't know what the chances are. We say it's 50-50. What's the attorney there for? What's the attorney doing there? If he's just going to say 50-50, if he can't address the chances of success at trial, if he can't discuss the trial strategies.
But the
to
trial
inform the
strategy is
client.
different than the chances of success. You never
Sure.
can gauge how you're gonna. You could think that you have you know this. We all know this. You could have the best case in the world, and lo and behold, the jury didn't believe a mint of it, and you lose.
Absolutely right.
So I mean,
Absolutely
it's
right.
all. That's why it's.
Counsel stated at the evidentiary hearing, and this is a fact, every attorney can assess the strengths and weaknesses of the cases. You don't know what's going to happen in trial. You absolutely don't. I think I have a strong case here today. I don't know what's going to happen with the outcome. No idea. And I advise my clients, here's what I think about the case. And I've done trial work too. That's, it doesn't matter that I've done that. What's the attorney there for if 50-50 is enough?
Well,
Anybody
but
can
your,
tell that
your
7 to 25
client,
years is different.
counsel, your client was adamant he didn't do it. It seems he set the trial strategy.
Okay, so yes, that now, I don't know about setting the strategy, but you went forward the strategy.
What is
you
the
have to come up with
strategy
one,
is I'm
right?
innocent.
You have to come up with one, right? Exactly. And Mr. Cortez was insistent. So that's the second prong. Is there a reasonable probability that he would have accepted the plea offer with sufficient advice? And he was adamant and insistent about his innocence, but there can be several reasons for that. One is, I'm innocent. And another is that in certain communities and certain families, a person might consider it better to go to prison than to admit before his family and his friends this kind of conduct. Now,
Right. I mean, these are the nature of the charge. It is often very difficult for a person who, even a person who did it to get to that point. If you're in a, close, and if it's a family relationship, particularly.
yes.
But in the evidentiary hearing, wasn't there some discussion by the defense counsel that I said, think about this and think about it overnight. And that he did that and came back and said, no, I still want to go. I mean,
Yeah,
didn't that
think
happen?
about what though? Think about what? Think about 7 versus 25 years. That's all he said.
What else, my friend? I mean, I don't know. Thank be to heaven. I've never had to make that decision personally. And I guess I don't think I had clients who were facing charges like this, but I certainly had lots of trials and plea hearings. What else is a lawyer to say?
A lawyer could say your chances here are low. Trial counsel did not state that he ever said that, didn't recall ever saying that, though he recalled a lot about the trial. And just to continue on about reasons why someone might state that they're innocent, that trial counsel himself was worried that it was about community and about family. And that's at page 5, and you can read that there. The trial counsel was concerned that Mr. Cortez's concern was admitting this in front of family and community. So that's one thing. Another thing is at the evidentiary hearing.
But what are you supposed to, as a lawyer, what are you supposed to do with that? I mean, if that's part of his culture, part of his being and who he is, that's just part of his decision-making process, the clients, not the lawyers.
Correct. Now, at the evidentiary hearing, Mr. Cortez did state that there was a time when he took a step back and began to think maybe he should take the plea because of the substantial difference in the time. And that statement, and that's page 21, that statement is credible. Who would not be taken aback by that amount of time? And in Griffin versus United States, the Sixth Circuit has held that when there's a substantial difference between the plea offer and the ultimate actual sentence after trial, it can be presumed and assumed, I should say, that the defendant would have taken the offer with sufficient advice. So Mr. Cortez asked the court to find that he had insufficient advice that led him to go to trial. Nothing about the strength of the case. Nothing about, hey, buddy, you don't do this. I'm not saying he should say that, but or any particular thing that he should have said, but he should have said something about the strength of the case. We asked to find that there's a reasonable probability that would have accepted the plea offer had there been sufficient evidence. And we asked the court to remand to reoffer the plea.
I just want to
Yes.
push back a little
Sure,
bit,
yes.
counsel, on something.
Thank you.
And all of us are former trial court judges.
Yes.
In my mind, I have this vision of day one of trial and the defendant saying, I want a new lawyer. This guy thinks that the deck is stacked against me. I want a new lawyer. So, I mean,
I've been there.
you know what I'm talking about,
Right.
right?
Yes.
So how, I'm trying to reconcile that with the idea that the attorney should have done more than 50-50 analysis.
And I remember when the statute changed when I was on the court and it became the 25 minimum, and everyone in the criminal defense bar and the criminal docket judges were, wow, okay, that is a big change.
Mhm.
And like Judge Rick says, I mean, it's, oh my gosh. I mean, I was, as I was getting ready for call this morning, I have a ledger in my chambers and I happen to have the benefit of, I just have to come up one floor in a Grand Rapids call.
Right.
But I have written down 100% of the trials I had, the actual trials. And there were a couple hundred of them plus. And oh my gosh, every case. And this case call has many cases like this. And it's just, I don't know.
I wish counsel said something about the chances of success at trial, and apparently he did not.
Well, I wanted to say I appreciate your argument. You did a very good job, and this is on video. So if new lawyers could see you because of your citation to the record and your nice, calm, professional presentation is appreciated.
We're
Thanks
gonna
very
have you
much.
cloned.
Yep, thank you very much.
Yeah, thank you.
Yep. And the prosecutor was not endorsed, so the case is. Item number 15, docket number 364432, People versus Carter. We have defense counsel endorsed and the prosecutor is not, but she's here. Morning.
Morning. May it please the court, Ally Wright from the State Appellate Defender Office on behalf of Mr. Carter. I really was hoping just to maybe focus my argument today on the first claim raised in the brief on appeal with respect to pre-arrest silence. But of course, if the court has any questions about any of the other claims raised in the brief, I'd be happy to answer them. In Collier, our Supreme Court mandated that the use of pre-arrest silence should be approached with caution. And I'm asking this court to approach Mr. Carter's case with the same level of caution. We can get into some of the complexities of pre-arrest silence and
Collier did involve pre-arrest silence in response to custodial questions from law enforcement.
I believe, and we can talk about Dye, Collier, and Sutlinsky, but I think that those are essentially the issues.
Okay, and that is not the case in this matter. This was an aunt of one of the two decedents called your client and made statements, and that was what was brought before the trial jury, correct?
I'd push back there, Your Honor. The aunt is calling at the behest of police, and I think this is
She is not a police officer.
she's serving as an agent or a mouthpiece for the
Oh,
police
come
officer.
on.
She is not a police officer.
I agree with you. She's not.
Okay, and she is, and the defendant, because he's receiving a phone call, obviously is not in custody, correct?
Correct. And I
Okay,
don't think
so
there's a requirement.
there is no Miranda issue, right?
This is a question of pre-arrest silence, it's a bit
Okay.
different than Miranda.
All right, pre-arrest silence
Sure.
from a question from the aunt of the person who he used to be in a relationship with.
So I
Yes,
just want to make sure.
yes or no?
What was your question? I'm sorry, Your Honor.
Pre-arrest question from the aunt of the decedent. And the decedent is a person who the defendant was previously in a relationship with. Is all of that correct?
That is all correct.
Okay. Thank you.
I think I wanted to, I guess, respond to, I believe, two things you raised in your question there, Judge Redford.
Okay.
One, you touched on Miranda. This is really, and I think this is borne out by our Supreme Court cases in Dye, Collier, Sutlinsky. This is a question of relevance. And they talk about it, that this is really supposed to be considered in the context of relevance. And then two, and it seems that the court's issue is this is not coming directly from law enforcement. And there's no requirement you're in custody. That's why we're talking about pre-arrest silence. But it's not a direct communication with law enforcement. Again, the aunt is at the crime scene when they discover the bodies. Law enforcement is there. Detective Anderson is there. They're doing their thing. They immediately hone in on Mr. Carter as suspect number one, ex-boyfriend, tumultuous relationship. And this is all testified to. The aunt testifies, Detective Anderson is right here, right? And she wants to speak to you. The only reason that the aunt knows that Detective Anderson wants to speak to Mr. Carter is because, as she said, Detective Anderson is right next to her, and she is essentially talking on behalf of Detective Anderson to the client or Mr. Carter and serving as a mouthpiece for the police. So I understand, I'm not saying that she is some official endorsed agent of the police, but I do think there's this perverse workaround that I take issue with, or Mr. Carter takes issue with, in terms of the police being able to get around his rights or his pre-arrest silence rights being triggered by just having an aunt or a friend or whoever call you, and then the police officers.
So anytime the police are investigating a crime scene and they find out that someone there knows someone who has a former relationship and maybe it could be a suspect, go ahead and call them.
Sure.
Tell them I want to talk to them. That's all of a sudden the police, that's no, what case says that?
They can.
What case law says that? I've not seen a thing that says it.
They can do that, Your Honor. What can't happen is that the prosecutor can't use that against you at your trial.
What case is like this one, where no police contacting it's just a third person not related to the police who makes a phone call to a suspect, and then that silence is then put into evidence.
I think the court's going to have to decide that. I don't think there is a case where there is this third-party medium, but I think the question for this court is when an officer tells someone, call this person on my behalf, and I want to talk to them, can that be used against that person at their trial? And I think it's I find it, and Mr. Carter finds it, and I hope this court finds it problematic that can be this kind of loophole. I do consider it a loophole. There's this kind of workaround where we can now say, oh, it's technically not direct police contact, because if it was direct police contact,
When you say it's a workaround, it's like you're saying this is a preconceived notion to do, as opposed to it just came up. I mean, the police didn't plant the ant there so that she can then go call
Right.
them. It just happened.
The aunt got a
So
call
they're dealing
that
with
her
a circumstance
beloved niece
of the
says something's happened to her. They don't even tell her that she's dead.
anyway. We understand what the argument is. So
Well, and I just want to add that, I mean, does the situation change? What if he were not even a suspect? He was just a party who might have information, and the police do not have a suspect, but bear with my hypothetical, down the road, oh my gosh, he was the person. So I mean, does the intent of the police or the instructions of the police make a difference in the argument you're making? Because I don't know that they necessarily said, it's this guy, that's why we want to talk to him.
I think it does. And I think they kind of did say, is this guy, we want to talk to them, because I think this is borne out by the aunt's testimony. Mr. Carter was an immediate suspect within seconds of this murder. Then the police and everyone in the town shows up to the crime scene. They talk about everyone saying, Mr. Carter did this. The police then say, well, we want to speak to Mr. Carter. So he's suspect number one from second number one. When he's being contacted by police through the aunt, it's with the notion that he's suspect number one. And it's not surprising. I mean, I think this court, and we all know, we've seen enough cases. Of course, we all think that the husband or the ex-boyfriend, particularly given the tumultuous nature of this relation, is always suspect number one. And I did want to circle back. Again, it's questions about relevance, but again, this is really about, it's really only supposed to, and these are borne out by those Supreme Court cases. And I think it's surprising to me that the prosecution didn't cite any of those Supreme Court cases in its brief. They didn't cite Dye, they didn't cite Collier, they didn't cite Sitlinski. They avoid them. I think they avoid them because they're not very good for them. But this is all about impeachment. The only time this can be used against someone is for purposes of impeachment. Mr. Carter never took the stand. He never testified in his own defense. He never even offered an alternate version of events for purposes of the defense. There was nothing to impeach. And the prosecutor admits, and I think I guess I applaud them for being honest, but they admit that the reason that they're using this is as substantive evidence of guilt. And I don't see any cases saying that you can use this type of pre-arrest silence as substantive evidence of guilt. Someone not talking to police as evidence that they've therefore committed a murder.
You might want to address why it's, assume you're right for a moment. You have an eyewitness who sees the defendant moments before, hears gunshots, it sees him later, immediately thereafter, identifies him in a photo lineup, as I understand. So how, if you're right, even if you're right, how does that impact the ultimate result of the appeal?
I'm glad you asked that, Judge Redford. I think this is discussed a bit in claim number 2. But that witness, you're talking about the mail carrier, that witness identification, and I think this court can hopefully see that, is highly problematic. Why? It's undisputed.
I see you argue that. I just don't see the facts that support your arguments.
So I think, and just to make sure we're talking about the same argument, the argument being the mail carrier saw on the evening news the night before she does this a photo of Mr. Carter wearing prison orange and essentially saying he's wanted for this murder.
Person of interest.
Sure, person of interest.
Is
Sure.
what it said.
Sure.
It didn't say
Wearing
wanted.
prison orange. And then essentially the next day, she shows up to do an identification of the same person that she saw in the evening news before in prison orange.
With a different photograph, depicted differently, different facial hair than the television depiction, than the photo lineup. And while she was observing the defendant before the shooting takes place, she is talking to a colleague and says remembers him vividly because he was so handsome, particularly his lips, she said, and multiple times. And she said, I'm 100% sure it's him. I mean, how do we have it's the wrong identification?
So the issue there is not just her identification, it's also the claim was raised as vouching. And if you recall, the claim is that specifically Detective Anderson, who is not the mail carrier, is asked whether her identification is reliable or whether it's essentially been corrupted by what she saw on the evening news before, the client in prison orange. And she says absolutely, Detective Anderson says absolutely not. And so the claim there, the issue there is there's this vouching for the reliability of the identification of the mail carrier. And I do think the mail carrier is very important to the government's case because we do have a murder with no murder weapon, no forensics tying the client to the murder scene. And most importantly, his phone. I mean, I also take issue with this. His phone's at home. So the phone shows that during the time of the murder is at home. And I think this court has seen it argue both ways. If your phone's at a murder site at the time of murder, that's not good for you. I mean, that shows you were there. But now that the phone shows he's
Now the
not
argument is if your phone's at home, you obviously premeditatedly planned this because you're a criminal mastermind.
Correct.
And you left your
And
phone.
I don't think the government can have his cake and eat it too. I really take issue with them arguing it both ways. That in some case, your phone's there, you must have done it. Oh, your phone's there, it must have been you're smart enough to leave it at home. Like, which is it? In any event.
And isn't that up for the jury to decide?
Sure, but the issue here again is vouching, right? The issue here is a question of whether Detective Anderson can speak to what's going on in the head or the reliability of the mail carrier's identification. She can't. She's not an expert.
Mr. Beeson, who is just a superb lawyer, was the trial counsel in this case, the defense counsel. He's asking probing questions in cross-examination, in challenging the efficacy of the government's case. Does the government have the ability to then come back and ask rehabilitative questions about the legitimacy of some of their evidence, which has been tested by the excellent advocacy presented on behalf of your client by his counsel?
Absolutely. I think they're doing it through the wrong witness, though. They can go and ask the mail carrier, and they did this. How sure are you of your identification? Of course, Mr. Beeson can test her on that, et cetera. But what they can't do is then take this third-party police officer who's not an expert in eyewitness identification, who is not the mail carrier, who wasn't there, and then ask her, by the way, this other person, when someone sees something on the evening news, someone wearing prison orange, does that affect their identification? Detective Anderson was not qualified to testify about that. That's vouching.
Okay.
Um,
Thank you.
I did briefly just want to circle back to pre-arrest silence, just in terms of, I discussed Collier and I believe Dye, this notion that this court should approach pre-arrest silence with caution, and then that it's really only supposed to be used for impeachment purposes. And in all the cases, the court is really supposed to be looking at whether it would have been natural for someone in Mr. Carter's position.
The case of People versus Scholert or something like
Yes.
that? That doesn't limit it to impeachment.
Well, I would. So Schaller is, again, distinguishable. I believe I spent a paragraph or so in the brief on appeal distinguishing that case. But I find that case highly distinguishable actually for the reason I was about to talk about in terms of whether it would be natural for someone in that situation to speak to authorities or law enforcement. Specifically in Schaller, police show up. It's 3:30 in the morning. The defendant there lets them right into the house, acts like nothing's wrong, literally says, and this is a quote from that, "Come on in," very weird behavior.
You don't, we can read the case. You don't have to
Okay,
go through all that.
so.
You're about out of time too, so.
Okay. Well, then if there's nothing else, I'm asking that this court treat the use of pre-arrest silence in Mr. Carter's case with the same caution our Supreme Court has asked, and that consistent with that jurisprudence that this court find is improper for the prosecutor to use Mr. Carter's failure to communicate with the police to proactively reach out to police against him as substances evidence. of his
Okay.
guilt.
All right.
Thank you very much.
Thank you, Mr. Wright.
And
Nice-
Ms.
nice
McMurtry,
argument.
you're here. You're not endorsed. Does anyone have a question?
I don't
for the
have any at this
prosecution?
time.
All right. Thank you for being here. That matter is submitted. Item number 16, docket number 366119, or I'm sorry, 366914, People versus Nevels. And both sides are endorsed. Do we have no? Get on. Oh,
Are you covering for him or? And, okay,
all right. Thank you for letting us know, though.
your co-counsel, I'm sure is, or brother counsel is very upset that he's not here. But,
Heartbroken, Your Honor. Good morning, Your Honors. I'm Garrett Burton. I'm from the State Appellate Defender. I represent Mr. Nevels. So as you know, I raised several issues in my brief. I would like to talk about the alibi notice, the forensic interview, the impeachment, and the sexual contact piece. And so first, Your Honor, as the prosecutor conceded, the trial court erred when it wouldn't allow Mr. Nevels to present an alibi defense. That prejudiced Mr. Nevels first, because the jury did not receive an alibi instruction. And second, because the jury didn't see the lease that this court remanded after this court remanded to the trial court so that lease could be made a part of the record. You have that now. The jury didn't get to see that. What that lease said is that Mr. Nevels did not live next door to the complainant for about 1.5 years of the 2-year period during which the prosecutor alleged that this could have taken place. And without that information, the jury couldn't appropriately evaluate Mr. Nevels' defense at trial. Second, Your Honor, the prosecutor in the prosecutor's brief doesn't engage with my argument about the forensic interviewer. So the prosecutor spends a lot of time talking about how the forensic interviewer did not testify to any of the hearsay statements that came onto the record. And I agree with that. That's true, obviously. My argument is rather that the forensic interviewer was an expert. And as an expert, the forensic interviewer needed to base any opinion on the appropriate facts and data. And under MRE 703, that data has got to be in evidence. And the statements upon which the expert based her opinion, the statements elicited at the forensic interview, were not in evidence. And as a result, the opinion that the forensic interviewer rendered was inadmissible. I'll keep moving along, Your Honor. So third,
Yeah, we'll speak up if we have any questions.
I trust that you will.
I do have some questions for you about your the challenge to the sentence.
Oh, okay.
But we can get to that when you're done with your.
Sure. So I'll move through quickly with the other stuff then, Your Honor.
I do have a question, I guess, on the forensic interview. So it's the defense's position that in order to have this the testimony in these types of cases, in each case, you have to admit all of the underlying studies, reports, analysis, interviews, CVs. Is that something that requires a Daubert hearing there, a Daubert hearing?
Yes and no, Your Honor. So I want to direct your attention to Yost. And Yost says basically that the background science literature doesn't need to be in evidence. So the forensic interviewer.
Well, if that was what was relied on partially,
Yeah.
why doesn't it have to be in evidence?
Well, I mean, I think that part of Yost is maybe wrongly decided. I'm not quibbling with that here because I think that all of the data that needed to be in evidence wasn't, specifically the the statements by the child at the forensic interview. I think that maybe you can sort of reconcile that tension because the forensic interview statements are hearsay and the background information is not. You know, we have a hearsay exception for that sort of background and periodicals, learned treatises, things like that. That's not hearsay, and out-of-court statements are. And so that's how I think you can reconcile those two ideas. And that's what I think Yost is getting at. But in this case, you know, that necessary information, the out-of-court statements were not admitted. Third, Your Honor, the prosecutor conceded again that Judge Losada improperly denied Mr. Nevels the opportunity to impeach the complainant. And I think that preclusion by Judge Losada had a big impact because, again, the complainant was giving shifting explanations for what happened, and the jury didn't have the opportunity to learn that. And the last thing I wanted to talk about was the rape shield stuff. So since the prosecutor and I have briefed this, the Supreme Court has overturned Massey, and that's a case that I rely a lot on, and the prosecutor addresses in the prosecutor's brief. And the Supreme Court kind of said we're both wrong, I think. And so under Massey now, this is sexual contact. When minor complainant views pornography or happens to experience pornography, that's sexual contact, and it falls under the ambit of the rape shield. What the Supreme Court also did in Massey is they changed the Morse test. So they said there doesn't need to be a conviction. There just needs to be a determination by the trial court about the relevancy of the evidence. So I wrote down the whole thing from Massey. What the Supreme Court said is we hold that once a sufficient offer of proof is made by a defendant, the trial court must hold an in-camera evidentiary hearing to determine whether the defendant is constitutionally entitled to present particular evidence that is otherwise excluded under the rape shield statute. And so that in-camera evidentiary hearing didn't happen here after trial counsel made that offer of proof when he tried to cross-examine the complainant about that. And so I would ask that you remand this case so that the trial court can make that determination consistent with the holding in Massey.
When was that decision? And when was the decision of the Supreme Court? And when was the decision of the trial court?
Yeah, the trial court was in 2022. And so in 2020, or the trial was in 2022. And at that time, it was not clear whether this type of material constituted sexual contact such that it was under the ambit of the rape shield statute. The trial judge, Judge Losada, found that it was barred by the rape shield, correct? No, I don't think that's right, Your Honor. I think that his ruling is actually really not clear to me. I think he's excluding it.
Did he allow it or not allow it?
He didn't allow it, but I think on relevance grounds. So the prosecutor objected, saying it's irrelevant and it's rape shield. And at the time, trial counsel was trying to cross-examine on a couple of different things. And so I think Judge Losada's ruling is not 100% clear, but Judge Losada ultimately says this is irrelevant.
It's not coming in.
Yeah, it's not coming in.
And under the new pronouncements of the state Supreme Court, probably the same result.
You know, I don't know. Because in Massey, I think it's very similar to the type of evidence that is here. And the Supreme Court in that case didn't make a determination one way or the other about whether it came in. They just remanded to the trial court to make that determination. And that case hasn't come back up. So I'm not sure what the trial court did. And there hasn't been an appellate court that has either affirmed or overturned whatever happened. And so just to get the timeline clear, this happened in 2022. In 2023, when I wrote this, or in 2023, the Court of Appeals said this is not sexual contact. Right. I wrote the brief in 2024, and then in 2025, Supreme Court made its decision.
Okay, so 3 years, is it? Did the Supreme Court tell us whether it's retroactive or prospective?
No, that's not part of the analysis in the holding, because it was, as the prosecutor points out in the prosecutor's briefing, in Massey, it's an interlocutory appeal. So I think that can maybe affect the analysis a little bit.
One of your arguments is that the 25-year minimum is cruel or unusual. You don't cite the two binding decisions from this court, one in 2011 and then one in 2025. Why is that?
Well, I don't think there is binding case law in this court about.
You don't?
Not with regard to a blanket 25-year sentence. I think as applied to Mr. Neville's, we can make that argument. And
Is that what your was? I mean, it seems to me that you should have at least cited those and then said why they weren't applicable.
which,
And you instead you cite something that the Obama administration did on some discretionary executive action
Mhm,
and some a piece from Bridge Magazine
mhm.
and something else, none of which has any controlling authority at all.
Your Honor,
I'm very, go ahead. What's your explanation?
sure. I cited those as evidence about how to apply the 4-factor test to decide whether a punishment in the state of Michigan is cruel or unusual.
Oh, really? We look at what a presidential administration did in 15 years ago?
Yeah, I
That's
think,
relevant?
yes, Your Honor.
More relevant than a published case on the exact same statute issued by this court.
That was reaffirmed last year.
Well, again, Your Honor, I wrote the brief. before
Which
it was reaffirmed.
which is more relevant,
Uh-huh.
published controlling law of the state of Michigan issued by the intermediate tribunal that you're appearing in front of,
Mhm.
or a administrative decision or recommendation or assessment, I don't know what, of some different branch government, different governmental entity, which is more important that an advocate bring to the attention of the tribunal that has to decide this?
Your Honor, I agree.
What do you agree?
That the published case law is
Okay,
more
then
important.
Why didn't you put it in there? Was it, look, just be honest. Was it a mistake?
Are you
were
talking
you-
about, I just want to be clear about what you're talking about, Your Honor. Purtle? Are you talking about Purtle?
It's called, I think it's called Benton. Yeah, People versus Benton and then People versus Sattler Van Wagoner.
Okay. Well,
And they're on the same, like Judge Redford said, the same statute, the same argument, cruel or unusual. And it's been a dead issue for a long time. And then you make this argument and you don't even cite these cases. You don't even mention them.
I guess, Your Honor, I apologize because I was under the impression I was raising it as applied to Mr. Neville's. I wasn't aware of those cases. I apologize. I concede, don't misunderstand me. I concede that this court has decided that as a general rule, this is an okay punishment. My argument was with regard to Mr. Neville's, and I apologize if that was not clear in the way that it ought to be.
All right.
With that, Your Honor,
All set?
yes.
All right. Thank you very much.
Mhm.
And I guess no one's here for the prosecution, so that case is. Oh, yeah, you're on the next one.
Mhm.
Item number 17, docket number 370257, People versus Hinton. And we do have the prosecution here. All right, Mr. Burton?
Yes, Your Honor. So I'll be quicker this time. My name is Garrett Burton. I represent Mr. Hinton. I'm from the State Appellate Defender Office. As you know, this is a case where I am substitution counsel, and I really would like to just talk about my supplemental brief and touch mostly on that identification piece, and then talk briefly about the other two issues. So, Your Honor, the prosecutor in the prosecutor's brief concedes that this was an in-court identification. And as you know, under Posey, an in-court identification is inherently suggestive. So that compels us to ask whether there was an independent basis for this identification, and I don't think that there was. You know, the officer only was able to see my client for a brief amount of time. He didn't have a previous relationship with him. There's really nothing to suggest that other than that 4 or 5 minute encounter that
The officer testified. He was with your client, like you say, multiple minutes
Mhm.
within arm's distance,
Mhm.
that he specifically focuses on remembering unique and identifiable information about the person who is in front of them, so as to be able to recall with clarity later their countenance. And he said your client had tattoos on his forearms. He described his face. He goes through all that. And then another officer takes a photograph of him from a distance. And then the next day, he sees him again with the unique white ball cap, apparently, that he chose to wear as a chapeau as he walked around the Hartside district of this great city. I'm really, I mean, really, you're saying he couldn't identify him after spending 4 minutes with him?
No, Your Honor, I think 4 minutes is a really short period of time. I think the description that you're.
One thing I found interesting as a trial judge, I remember a lawyer asked a witness, he said, how long was it? 30 seconds. Okay. Let's everybody be silent.
Mhm.
I'm not going to ask us to be silent for 4 minutes.
I've
But you
seen
get
the
my
trick.
point.
Yeah.
It's 240 seconds.
Mhm.
That's a long time.
Your Honor, I disagree, as you know. And I think what the bigger factors of the Kachar factors measure is not only that, but also the amount of time between when the identification took place and when trial happened. And that was about 1.5 years later.
The double identification. He identified him twice. The next day, he specifically identified your client. He's back here. This is what he's wearing. He's not wearing the same shorts, but he has the hat on. So he identified him 2 different times.
Well, Your Honor, I would talk a little bit more about the characteristics that you described a little bit earlier. So when you're talking about how he has tattoos and a hat, I think those are really not very descriptive characterizations of the individual who the officer thought was my client. And so I think the balance of those factors weigh against finding that this was an independent identification.
Okay. Understand your position.
Yes, Your Honor. Lastly, with regard to the other 2 issues, I'll just touch on them briefly, Your Honor. I think they kind of go hand in hand. I think that Mr. Hinton wasn't able to effectively challenge the testimony that these were drugs. One, because there was this confrontation violation. The chemist testified that another person said that she did a good job, and then he didn't have the data that was necessary to attack it. And so I think those 2 things working in concert together made it difficult. And the last thing I'll say is that when we filed the motion to remand in this case, Judge Rick, as you might remember, you wanted to remand. So I would ask for that same relief here, that we remand for an evidentiary hearing.
You have plenty of time for rebuttal.
Yes, Your Honor.
Good morning, Your Honors. Audra Blodgett on behalf of the Kent County Prosecutor's Office and my colleague Catherine Wendt, who is in the Supreme Court this morning arguing.
Who?
Which
case?
Oh gosh, don't get me in trouble.
A case.
sir.
People
A
versus
case.
somebody.
A probable cause of a search warrant is the issue. So
I heard parking was tight today.
I
Oh.
think there's a suit between the Senate and the House that's
Yeah.
causing quite the
Yeah.
attention
Oh,
today.
the transfer of signed bills, or not signed, the transfer of past bills by a new House panel. Yeah, that would be,
She's first.
that'd be a
thankfully.
crowded day.
And
Oh, she's ahead of them?
Into that,
Oh, that's
yeah,
good.
she's
Yeah,
first.
because that one might take a while.
I think it drew quite the crowd, so she'll have.
Did we address
have
it?
the
Did our
audience.
court? We
Yeah,
must
I
have.
wrote a dissent in the case, so I'm hoping they go, but knowing them, they won't. But anyway.
On to this, Mr. Hinton's case. I don't have much to add to Ms. Wendt's briefing. I'd be happy to address any questions the court has. I would just emphasize the indicia of reliability that Judge Redford brought up this morning about the identification of Mr. Hinton in court by the detective. And then just in general, emphasizing the Posey decision and what I believe to be their overarching warning, just guarding against identification evidence that's rendered unreliable by state action. And I don't think those same concerns are at play when it is the state involved in the investigation, although the detective is a lay witness. I think his training, experience, involvement in the criminal transaction as a law enforcement officer is not the same type of in-court identification that Posey is concerned about. But I'm happy to take any questions on any of the issues raised.
What, I do have one question. What about this lab? I don't know whether it basically boils down to almost a hearsay type thing, I think. I don't know, but
The right to confrontation with the lab
yeah, why is
analyst.
that not effective?
First, I think that the case law says her testimony, I believe it was a female lab analyst, was not testimonial because the purpose of her involvement in the case was quality control. She didn't do any of the testing. She wasn't involved in the creation of the report, but kind of just reviewed it as a process step with the lab.
The person who wasn't there.
Correct. The person who was not there was just kind of the quality control, making sure they followed the correct process. So I think it's not testimonial. The purpose was quality control, not a focus on preparing for litigation. But even if this court were to find that they should have been called, I don't think it would have affected the substantial rights. It would just be another person coming into court saying how good this lab analyst performed.
Right, but I mean, we do that all the time in business records. You know, if the parties don't stipulate to custodians, they're required to call them in. Why is the government not required to call them in?
I think
Or to obtain an on the record stipulation that you don't need to.
I think because this non-testimonial would be the first, they did not think they were required to have them come in. The case law is saying that quality control is not testimonial. But let's say they were required to call them in for your purpose. I don't think it would have been plain error, no prejudice or substantial effect on the outcome. The defense was to contest the identity of Mr. Hinton in this case, not necessarily that what he sold or what he was alleged to have sold was or was not a controlled substance.
I remember defending drug urinalysis cases a lot as a defense counsel in the Navy, and man, they had to bring in everybody.
Yes, and
Yeah,
I think
so-
that is why the lab analyst definitely had to appear and did
But I'm saying they had to bring in the person who watched the person pee. They had to bring in the person who mailed it. They had to bring in the chain of custody was essential for
Yes.
reliability of the test.
And I don't think the quality control person would have affected the chain of custody at all. The drugs did make its way through the standard chain of custody. It remained with a lab analyst who did the testing, wrote the report that all went into court. So I think just kind of the oversight wouldn't have affected that chain of custody analysis at all either.
Okay.
We're all
Thank you.
good.
Thank
Thank you
you.
very much. Any rebuttal?
So that testimony was testimonial. The hearsay statement was testimonial. So I agree with the prosecutor that some quality control is not testimonial. Making sure instruments are working properly, things like that. But when someone reviews a specific output from a chemist and gives it a stamp of approval, that goes beyond mere quality control, and that becomes testimonial. Obviously, that individual who is giving the stamp of approval is giving that in anticipation of litigation, which is the test for a testimonial statement, and that's why it violates the confirmation clause.
So are you raising this in the context of an ineffective assistance?
Yeah, I believe I did.
Okay,
Yeah.
that's my recollection too.
Yeah.
We have a bunch of cases today
Yeah.
and yesterday, so I want to verify. So here's my question. If it's in the context of ineffective assistance that it wasn't objected to, had trial counsel objected to that testimony on this basis,
Mhm.
why wouldn't, if that had happened at trial, couldn't the prosecution at that point then seek to amend their witness list to bring in, whomever? And I mean, it becomes obviously a logistical problem.
Mhm.
You're in the middle of a petite jury trial,
Mhm.
but I mean, if that happened, wouldn't they have had the opportunity to correct it? And if that's so, then how is it outcome determinative to give you relief under an IAC claim?
Yes, Your Honor. So I think a couple of things. First, I think it was too late to correct the issue. And I don't think that the prosecutor would have been permitted the opportunity to amend their witness list such that this individual would be able to come in. The
Why
other thing
not?
else,
Yeah, why?
Just because like Judge Redford talked about, it happened so late within the context of the petit jury trial.
I guess I don't buy that. I think it's speculative, but go ahead.
The other thing I'll say, Your Honor, is that there's really no reasonable reason not to object to this because of the chemist who did testify. So she was a really inexperienced chemist, if my memory serves me correctly. She, I think this was maybe only her first or second time testifying. And so when she testified to this other more experienced chemist saying she did the right thing, I think what that did is it really gave the trial attorney reason to object because it gave her testimony more weight than it was entitled to.
Okay. Thank you.
Yes, Your Honor.
Very much.
Thank
Case is
you.
submitted. Remaining for the next two, right? Item number 18, docket number 366762, People versus Lofton.
May I please the court, and good morning, Your Honors. Ian Kerpaw on behalf of Mr. Lofton. So the main issue in this appeal is the ineffectiveness of the counsel of his trial counsel. This court did remand this matter back for a Ginther hearing, which we held. Ginther hearing was over 2 days. So the main issues at the Ginther hearing were the failure to call certain witnesses, trial counsel impeaching her own witness, and then not advising her client to basically testify that oral sex happened on direct. Turning to the issue with the witnesses, and part of the prosecutor's theory at trial here was Mr. Lofton was making everything up, essentially. He made up Mr. Dykema, he made up Mr. Greiner, he made all these things up and attacked his credibility in that regards, and it's mainly his rebuttal. And that he also lied about these photos of the windshield. So when we get to the Ginther hearing, we have Mr. Dykema who does corroborate what Mr. Lofton said. Yeah, he came to this party, complaining witnesses with him, and at some point they left. You have Mr. Greiner who shows up to the Ginther hearing and says, yes, Mr. Lofton called me, he got stuck in the mud. I came there, got him stuck out of the mud.
Right. But when we read Ms. Foster's testimony at the hearing, and then you read the 14-page opinion of Judge Quist, Ms. Foster's basically, as I understand it, she's saying, I didn't want anybody there to say he took her to a party and she was intoxicated. She was at the bar and she was intoxicated because that would, she felt that it would impair the defense that this was all consensual and not participation in a sex act with someone who's incapacitated. And her arguments say she just blacked out. So I mean, how do we address that?
Yeah, I'm glad you brought it up, Judge. Because what's interesting about this case is when we look at what Mr. Greiner said, he got there at about 3-4 o'clock in the morning to tow him out of the mud. Okay. About 12 hours later, the complaint witness.
0.15.
Yes. There was testimony from the trial about how much she had to drink when she left the bar. Long Island iced teas, shots, 2 Hearted beer. You had 2 different bartender witnesses there. When it gets as much she had to drink. And then trial counsel's own arguments during closing arguments basically said, don't find my guy guilty because the complaint witness got drunk and had a blackout.
Right.
Right. Use your common sense. You can get to a point where you're highly intoxicated, still make decisions, and then later have a blackout.
Right.
These witnesses don't change any of that. We knew she was intoxicated. And I guess the point I want to make is if Mr. Dykema and Mr. Greiner had said, no, she was perfectly fine.
So
that would have ruined her credibility because obviously she's heavily intoxicated. Her BAC was a 0.156, like 12, 13 hours later.
Who was the person who had the party and the dog that the complaining witness was critical of how the person cared for the dog?
Mr. Dykema.
Okay.
Yes.
So if he had testified that when she was there, she was talking bad to me about how I take care of my dog, and she was obviously hammered at that juncture, didn't know what was going on. How does that not hurt your client? From hey, earlier, the first thing they did after they left the bar the eyewitness says she was really, really very drunk. Not like the bartender said, she was buzzed, but not wasted, or worse to that effect.
Right. Well, I don't think, and Judge Redford, I don't think Mr. Dykema indicated she was intoxicated, but I don't think he ever mentioned to the point where she was completely out of it and couldn't make any decisions herself.
Right, but he did say that she was acting erratically, and he told the defendant, you got to get her out of here.
Sure.
Oh,
And sober people can be erratic too, right?
Oh,
There's a
man.
gradation there.
Yeah. You should spend time with Judge Murray. I mean, yeah. Just kidding.
Spend time with me. You'll see the full range.
He's kidding.
I am totally kidding. He's the most well-reasoned and well-mannered and balanced.
So now he's
person
kidding
I know.
again. Anyway, let's go.
So somewhere in the middle.
Yeah.
No, but in all seriousness, so when we're looking at it from ineffective assistance, was the trial counsel, was that a strategic decision? And if so, was it reasonable?
Well, here's the problem, because my argument is she's intoxicated. There's no doubt about that. You can't get around the BAC from 12-3 times out of 156. That had to been whatever it was. I couldn't imagine what
It was high.
it was before earlier. And as trial counsel said, to get through hearing, the BAC is what it is. Like, it's hard to explain that away. So that's the issue we have. I guess it's
Your
there.
whole argument, and this is a question, is there really wasn't a dispute that she was heavily intoxicated. When she blacked out, I guess it's a different story, but she was heavily intoxicated. And these other witnesses that were not called, the friends, would have verified what your client said occurred during the course of the early morning. And even if they would have confirmed, at least some of them would have confirmed the fact that she was highly intoxicated. So what? It confirmed that he was telling the truth about what occurred, at least with respect to everything except for the acts that he got convicted of. Right?
Yes.
I mean, that's basically it.
Yes, because
Okay.
as the prosecutor argued to the jury, he told the jury most of what Mr. Lathis said is made up. That's what he said. He's got nothing to corroborate. I mean, the prosecutor argued at closing arguments. Hey, where's Mr. Dykema at? Where's Mr. Griner at? Where are all these people at? Where's the photo of the cracked windshield at? He's making it all up. So that's where, and when you have a CSC case like this, where it's a pure credibility contest, right? I mean, this is it, right? It's his word versus hers. I think the focus should be on what can we do to corroborate what Mr. Lofton is saying here. Because I think we can all establish that she's intoxicated. Absolutely. But the issue is, in Mr. Lofton, if he's telling the truth about, I went to Mr. Griner's, I got stuck in the mud, here's the crack in the windshield. I'm telling the truth that when we had sexual relations with her, she was able to make that decision.
What deference, if any, do we have to give to the trial court that had the Ginther hearing?
Interesting question, Your Honor, because motions for new trial are reviewed for abuse of discretion. I believe factual findings are for clear error, but then this is in effect, this is a counsel, so questions of constitutional law are de novo.
So a good deal of deference to the decision he made.
There is, yes. Yeah, it's not, his decision isn't de novo as a whole. But there's some different gradations there too.
I wonder if, if you could talk a little bit about the impeachment, because it seemed to me that was part of trial strategy, to your point about credibility, that the attorney elicited the UNP conviction of the client, again, consistent with wanting to be fully transparent with this jury, to bolster his credibility. Why do you see that as impeachment, or that it would be erroneous for the attorney, ineffective assistance of counsel, to introduce that testimony through the lips of the client?
And if I might add on to Judge Rick's question, in the context of the witness, the client answered the question a little bit differently than she anticipated. And then as the trial attorney, she's like, okay, well, this is maybe when we're at the podium asking the witness the next question, makes that, okay, well, I want to get this out myself. Why isn't that I remember your brief. You should have been, practiced more, should have been more prepared, but anybody who's been a trial lawyer has had witnesses say things that are surprising or not planned on. And then your job as the advocate is to try to mitigate the damages if necessary. And a follow on to Judge Rick's excellent question.
I thought it was convoluted, but thank you.
No, that wasn't convoluted.
I was convoluted.
Judge,
Yes.
I understand. And I agree. I do trial work too, and certainly you can't always anticipate what your witness is going to say. I completely understand that, and sometimes you got to think on your feet. I guess the issues I have here is the prosecutor said, "Listen, I'm not going to bring up this uttering publishing. I'm not even going to go there." So I guess in my mind, as trial counsel, obviously, if the prosecutor was going to go there, I would bring it out on direct. Absolutely on direct. I agree with what Ms. Foster said at the Ginter hearing, but that's not the situation we have here. In this case, where essentially trial counsel for Mr. Lofton essentially decided to bring it on her own. I don't know why she even went down this line of questioning.
And I think you characterized it as impeachment, and
Yes.
I reject that was it. What was she impeaching?
Credibility of uttering publishing conviction.
Okay.
There was no reason she had to bring it out or even go down that line of questioning. As she indicated at the Ginter hearing, I'm directing direct examination. I'm the one asking the questions.
Right, but you can't.
But that's an unforced
You can't
error.
ask leading questions, obviously. And I thought that at the Ginter hearing, she said when that happened, when he answered that way, I thought it's going to come in now. That was my impression of what.
And I guess Judge Redford and Judge Rick, it's an unforced error on her part because she didn't even have to go down that line of question at all. What was the whole
Okay.
point of even going there? There was none. I don't know why. I mean, obviously, if she knew the prosecutor was going to bring it out on cross, absolutely, I'm asking it on direct. But that whole line of question, I don't get it. Why she even had to go that way. And then she admitted, like, yeah, I didn't talk to Mr. Lofton about, I'm going to ask you this and how you should answer. So this is, unforced error on top of unforced error here. We really didn't have to even go there. And now the jury hears in a CSC case in the credibility contest, this guy's got an uttering publishing conviction. I mean, what are I supposed to take from that? So that's why I think it's just an unforced error on that part, which leads to the second issue, which is about the oral sex on direct, where she advised Mr. Lofton not to testify to this on direct. And of course, on cross, the prosecutor brings up, like, if I was a prosecutor, I would have brought it up too. And then, of course, that allows the prosecutor to argue during closing arguments. It's like the number one thing that to show consciousness of guilt is that he didn't testify to oral sex on direct. And, the prosecutor sort of hammered that part. And I think it was a pretty good argument on the prosecutor's part. And I don't know why. Well, she has an explanation for it, which I don't think makes much sense because you're talking about how the complaint witness is intoxicated and blacked out, and that's why she don't remember. I don't know why saying oral sex would be piling on or making her look even worse than what they were trying to portray her with her drinking and blackout habits. And then if it's there, it's in the discovery. Much like what we talked about earlier about bringing out the uttering publishing, even though the prosecutor doesn't do it, you bring that out on direct, just flesh it out. Don't give the chance to get impeached or even make it look worse on cross. So is this another unforced error? And then it does seem to be, she really does seem to advise Mr. Lofton, well, the prosecutor asked how to handle it. And I think he did the best he could. But it's just another unforced error there that really opened up and questioned Mr. Lofton's credibility to the jury.
Well, maybe so if it were pursued by the prosecution. They didn't.
Well, Judge Rick, I would, but they did on cross-examination pursuant, and during closing arguments on page 23, he argued that the number one thing to show consciousness of Mr. Lofton's guilt is that he didn't testify to oral sex on direct. I mean, that's what he argued to the jury. So they did use it. It's not like they just, mentioned it secondhand in closing arguments. I mean, that was part of their whole thing, right? I mean, Mr. Lofton's a liar. He's making everything up, and here he is. He's trying to hide this, so he's, even less credible now.
Okay.
And then I know we kind of skipped around, but just the picture of the windshield, we did produce that. And again, they're corroborating. She did kick my windshield. Mr. Griner obviously talked about her kicking around in a car to kick the windshield. Again, this would show I'm telling the truth about this, so I'm telling the truth. So that the complaining witness, I'm sorry, was conscious and able to consent.
And with that, I will rest the remainder issues on my brief unless there's any.
Okay, thank you.
Thanks.
It was a very good brief, by
It
the way.
really was. It was.
I've had you before. You always do good briefs.
Oh, thank you, Judge. I appreciate that. I guess I don't know if I have any time for rebuttal.
Huh?
I don't know if I have any time for rebuttal.
I'm sure you have a little bit, yeah.
Audra Blodgett, Kent County Prosecutor's Office, filling in for Katie Went. I am happy to take any questions from the panel. The one overall point I would make just based on the colloquy with brother counsel, the gist of his argument as to the witnesses trial counsel did not call seems to be that if she had called these witnesses, they would have cured a lot of credibility issues for defendants. But as I read the record and the briefing, even if they would have cured certain credibility issues, such as these people exist, they did go to a party, he did get pulled out of the mud, they would have created a whole slew of new credibility issues and provided testimony to the court and to the jury that worked directly against defendant's theory of the case. His theory of the case was that the victim in this case was conscious the whole time and thoroughly consented to the sexual encounter, only later blacking out, which caused her to lose memory of their consensual sex. But the witnesses in this case, when they testified at the Ginther hearing, provided quite a different picture of the victim's mental state at the time. The bartenders did say that when she left the bar after consuming some alcohol after work, she seemed fine, maybe buzzed, but definitely not to the level of intoxication that would affect her consent. However, by the time she arrived at this party and continued drinking, Drew Fields or Andrew Dykema testified that she was completely intoxicated by the time that she left the party. She was obnoxious.
What was the evidence of? I think at some point there's a representation that oral copulation takes place between leaving the bar and the first party. Is that right?
That's my understanding of the timeline.
And that the second act of coitus takes place after the party.
After the party and before the person shows up to take the car out of the mud. So the witness at the party described her as completely intoxicated. He asked that she be removed from the party because she was so obnoxious. And then by the time, so then there's the gap between leaving the party and the next witness showing up to tow the car out, during which time this sex act is alleged to have happened. By the time the friend comes to pull the car out, the victim is passed out inside the vehicle. When he begins to drive the car around to make sure it's okay to drive, she wakes up combative. He, quote, said she was severely intoxicated. He looked in her eyes. They were pitch black. He believed she was gone. She wasn't comprehending anything he was saying. So you call these witnesses at trial. Now it's not just a he said, she said. It's his friend, who he calls, describes this victim so contrary to defendant's own theory of the case that opens a whole new issue for defendant. And I would argue that counsel was not ineffective for reading these police reports, considering the available testimony, and deciding not to call these witnesses. I'm happy to take any other questions from the panel.
Any other questions? Okay. All right.
Yes,
All
thank you.
right, thank you. Any rebuttal?
And just very briefly. Just that there's no gradation of intoxication and blackout and consciousness and I understand what prosecutor's getting at. But again, just to reiterate, I don't think there's any dispute how intoxicated she was. And certainly she could have been fully aware and given consent at one point and an hour, 2, 3 hours later be in a position where she can't. So, which is in line with what Mr. Trial Counsel's theory of the case is we can be highly intoxicated at one point and then later we have a blackout because we're so drunk and high. So thank you, judges.
All right.
Thank you.
all.
Have a good morning. Yeah.
Appreciate you
Thank you very
taking these
much for your
cases.
briefs and arguments and the cases submitted. Item number 19, docket number 371910, People versus Shannon. Morning.
Good morning, Your Honors. May it please the court. My name is David Peterson for appellate Jonathan Shannon. I'd like to reserve 2 minutes for rebuttal.
Okay.
This case presents a constitutional defect in the imposition of lifetime Tier 3 punishment under the Sex Offender Registration Act. Mr. Shannon pled to criminal sexual conduct in the 4th degree involving a 13 to 15-year-old victim. Yet he received Tier 3 treatment, which requires that the victim be under the age of 13. This mismatch renders the punishment unconstitutional as applied under Michigan's cruel or unusual constitutional standard and the 4-factor proportionality test. Additionally, the fact triggering the Tier 3 designation, that being the victim is under 13, was never admitted and never found by required due process. Under Apprendi, that independently justifies relief in this case. Finally, because SORA is now deemed criminal punishment under Cardas, applying the 2021 version to the pre-2021 conduct in this case violates ex post facto principles.
Excuse me if this is not a good question. In that last argument about ex post facto, it makes a difference, does it not, if the requirements are, let me say that, if the requirements are basically the same under the prior version and the post 2021 version, it doesn't matter, does it? In other words, if the punishment hasn't changed, because as well, let me answer that first, I guess.
Yeah, I concede that if the punishment hasn't changed,
Yeah. But so
then
so
it's
then
not ex post facto.
that's what I was thinking. But so then I was trying to figure out beforehand, because this is the reporting requirements, right? That we're mostly concerned about.
I think solely, isn't it?
There's increased reporting requirements and increased.
But what are the increased ones? That's what I listed them out, like the 2021 reporting requirements and then the 21, the ones under the 2011. And it actually seemed like it was almost, there was less burdensome under the more recent statute. But so can you just tell me why it's harsher under the,
I'll do my best. The new statute requires reporting of internet identifiers and an email and has shorter time constraints on reporting change of address, job change, and it's.
And those things are
more-
significant enough
it's
to
more-
be, because I mean, those things, I guess I have to look back at the case law, but a shorter time period doesn't seem, does that rise to the level of a punishment? Like a harsher punishment, or is it, because, you know, you looked at you said the internet identifiers, the email address, but you know, you had the residence, employment, well, if you create an email or instant messaging, which I guess is because it's an older statute, you had that under the 2011, which is, I assume, similar to the email address and internet identifiers. I guess but your answer is a shorter time period and the addition of internet identifiers, and is it the email address too? Is that what we said?
Yes.
Okay.
Yes. On the whole, I think it creates more punishment for the people on the registry because they're more visible, they're more subject to vigilantism and shunning and things of that nature. That's a lot of the attack on the registry. I will address first, hit the high points of the cruel or unusual. And I mean, that's, you know, as this court knows, there's the 4-factor test. Jonathan Shannon is 35 years old. He was sentenced to 365 days which was much less than the time he had already served. This is a resentencing.
Right,
Sentencing.
and a withdrawn plea and all sorts of
Yes.
procedural complexities.
He was permitted to withdraw his plea for failure to advise of lifetime electronic monitoring.
Okay.
And he will spend the rest of his life on the Michigan Public Sex Offender Registry with quarterly reporting, public disclosure of his home, employment, his photograph, all mandatory, no risk assessment, no possibility of removal ever. He is not eligible. The specific category of individuals that could be removed, he is not one of them. Yet the conduct underlying this lifetime sentence is the single act of touching the clothed behind of a girl as she ascended a flight of stairs.
How old was he when he did this?
35,
So a
30
35-year-old
34.
touches the clothing over the buttocks of someone under 13. And that's not something that society has a right to have concern and interest about, such that people should be on notice of this?
I concede that, Your Honor. I readily concede that.
Okay.
But we're talking about tier 3. This is a surgical strike as applied to Mr. Shannon on his tier 3 designation. And it is a fact that that punishment does not fit the crime that is the count that put him on tier 3. He is being punished as a tier 3, which is the worst of the offenders.
But it's because of
For-
the age of the victim, right?
For a CSC 4.
If this were the same contact with someone who is not a child, he wouldn't be in tier 3, right?
That's right. The statute would
Okay,
for that.
why doesn't the legislature, the 110 members of the legislature and the 35 senators, what should happen as far as sex offender registration? Someone who does something like this to a child, why doesn't the legislature have the constitutional authority to determine what this punishment should be? The Supreme Court said it's punishment. Why can't they do that?
Our courts are full of historical cases that find that the legislature went too far.
Well, certainly recently, yes.
So, I mean,
But I mean, even looking at the 4-part test that's now been articulated, there are multiple states in the union that like Michigan, treat these things the same way with child victims. I understand the arguments. I don't know why it's cruel or cruel or unusual. There's no electronic monitoring. It's registration. He's not wearing a tether for the rest of his life. It is punishment.
but I'd like to submit to the court that it is unusual that he is being punished as a tier 3 offender for an offense that is not a tier 3 offense. It's
Okay,
it's
understand that.
and Michigan is an outlier in certain nuances of its sex offender registry. There's several states that use discretionary risk-based registration, in Massachusetts. And so there are some outlying parts of Michigan SORA
But what
that
do the
support factor
majority of
3.
states require an analysis of risk factors? Is that that's not the case, is it?
No, I don't think.
I think a couple of states do it. Why aren't those states the outliers? And in fact, Michigan is in the heartland, if you were to borrow it from the U.S. Sentencing Guidelines, body of case law, the heartland of how we treat these matters.
I think that there is so much to the Sex Offender Registration Act. And there's so many ways in which it is applied in an as applied situation like we have here, where this case meets the 4-factor test. It's a low-level CSC with the highest level tier 3.
Is there ever a tier 3 offender that has more restrictive SORA requirements than this defendant?
I'm
You
sorry.
Is there, if you're a tier, is there anybody in Michigan who's convicted of a sex offense that has more intrusive SORA compliance requirements?
No.
So there's no more lifetime electronic. Is that what you're saying?
There still is lifetime electronic monitoring, except not as applied to Mr. Shannon.
Right. What I'm asking is, and I apologize, my question's not very clear. Is what your client has to do, is that the most intrusive that could ever be imposed on somebody under SORA?
Yes. Yes. Tier 3 is got the most burdensome requirements.
So
for anybody.
if there's no person in Michigan, if they commit a forcible, violent CSC, they're 25 years old, 45 years old, whatever, with a 7-year-old, okay, and they have penetration, they're not going to have electronic monitoring?
They would, but that is a separate statute. That's separate sentence. The lifetime electronic monitoring was.
Oh, okay. So if you,
It's not-
there are
that's
things,
not
okay, so in addition to
I'm
whatever
attacking
SORA
here.
has, there are other lifetime applicable restrictions on, well, impactful aspects on their lives that are quite a bit more intrusive than your client is required to suffer.
not under the sex offender
I
registration
understand. I'm
as a
just
tier
saying, but-
3, as a tier 3 offender. He is the highest level, the same as the most severe sex offense that you described.
Okay.
Lifetime electronic monitoring is something separate altogether here.
All right. Thank you.
Mr. Shannon's attack is on the cruel and unusual aspects of his tier 3 designation for the specific count in the felony information that applied to. I'd like to turn to the third issue in this appeal. And that is a due process violation. This is unpreserved, subject to plain error review, and plain error occurred here. And I want to make an analogy. We know that SORA is criminal punishment. It's on the same footing as incarceration. And so the analogy is, instead of talking about SORA, on page 18 in the plea colloquy, where they were discussing what tier is it going to be on? Instead, let's say they weren't discussing tier 3 versus tier 2. They were discussing incarceration term of years. And the prosecutor suggested that, well, he's going to get 3 years of imprisonment. And the judge said, well, but this is a 2-year offense. And the response was, well, the warden is going to find facts that is going to result in the warden giving him 3 years of imprisonment. That would not stand up to due process analysis. But that's exactly what happened in this case with respect to tier 3. The plea colloquy went over this. The judge expressed his confusion that he's not pleading to a tier 3 offense. And the response was, well, the Michigan State Police Sex Offender Registration Unit will find facts and designate him a tier 3 offender. And a lifetime criminal sentence cannot rest on a fact determined by the police, never admitted and never found by the court. This is directly on point with Apprendi and Aline. Facts that increase mandatory minimums must be admitted or found by a jury. Cardas now confirmed SORA tier is a criminal sentence. And so this is very analogous to People versus Lockridge, which ultimately resulted in the sentencing guidelines no longer being mandatory, but advisory only, because the guidelines required fact-finding by a judge that enhanced the sentence. This is more egregious than Lockridge because it's fact-finding by the state police that would enhance that sentence. Mr. Shannon has served his sentence. What remains is a lifetime of mandatory public exposure, reporting and stigma for the single clothed touching on that staircase with no finding that he poses any future risk. That is cruel. It is unusual. It's being applied retroactively. And as I said, with respect to the due process, Apprendi, Aline, Lockridge argument, it was procedurally defective.
Did he waive that with his no contest plea?
I don't think that a no contest plea would be sufficient to waive that due process requirement.
Okay.
That's just relying on and the elements, that the under the age of 13 was not an element of the offense to which he was pleading.
Was it? When the trial judge, when Judge Sonnenfeld was making the determinations on the no contest, was he provided with police reports? How did?
Yes.
Okay.
Yes.
Did the police reports reflect the complaining witness was under 13?
Yes.
How is that not waived then?
Because that's insufficient to waive his due process.
He's literally getting a plea agreement that he's leaving jail that day, basically, right? Yes?
Yes.
Okay.
Well, I mean,
And so
there's some time.
yeah, but I mean, it's 500 and some days of confinement credit and he sentenced to 365 days. So there's a plea agreement. He says nolo contendere for whatever reason. If judicial officer has provided reports, the reports reflect that the complaining witness is under the age of 13. This is a matter of record that would qualify for the tier 3. I just, how do you get to enter? I don't contest anything. And then, oh, wait a minute, I do contest all this stuff. That they seem like they're mutually exclusive theories.
Count 3 does not require the victim to be under 13. It's actually just the opposite. It's 13 to 15. That's number 1. Number 2, agreeing that the police report supports the elements of the offense of conviction is not an admission of an additional sentencing fact that's not required by those elements. The tier 3 designation requires a
The-
separate
the
finding
statute
that's
for
not supported by the
sentencing
police.
statutes provide that the trial court is entitled to consider the record. Fair?
Fair. But the
Okay.
police report's not necessarily a matter of record.
It
at
wouldn't
the
have
plea
been,
proceeding.
it never would have been if your client hadn't agreed to proceed nolo contendere. Your client, through counsel, made that decision. So how do you get to then say 1 year later, 2 years later, however long a period of time is, oh, no, you can't do that, judge. I mean, that's fine. If you don't want the judge to do that, then let's have what we call a trial. When you agree that that's the basis upon which your criminal liability is going to be based.
There was an agreement that the police report would be provided to support the elements of the offense pled to.
Is that what was said
without-
on the
without the
record?
admission.
He said the lawyer was that precise and said, oh, you may consider that. And if it is, that's the most precision I've ever heard in a NOLO case. You may consider this, Your Honor, for the elements of the offense. What normally happens, and admittedly, I only had 6,000 felony cases when I was a circuit judge. They said, Your Honor, you can look to the trial, the police report is going to provide the factual basis.
That's what was said.
Oh, okay. Well, then there's a factual basis, which has all of this stuff. Okay. I understand your
and-
position. I respect it. You're arguing it exceptionally well and very, with a lot of precise authority. And I have great respect for that. So thank you for your arguments.
Thank you very much.
Counsel, I think I'm looking at your brief. There is in the record, after there's this colloquy about tier, what tier, and the judge said, this doesn't seem right, even though he's not pleading to for a tier 3 offense per se. Later on in the hearing, the trial judge said the charging document doesn't make this a tier 3. The prosecutor then indicated there is a factual basis for the 3 counts, and that part of the plea agreement required 3 different victims, one being less than 13, the other 2 being 13 to 16. That seems pretty sufficient that he knew before he went forward with the no contest plea and did that. That was all laid out there for him. But again, to Judge Redford's point, he gets to leave jail. So taking the deal. I mean, I just think he wishes he didn't bargain for this agreement after the fact.
The plea colloquy says what it says. Tier 3 was discussed at the plea.
As was age of the victims, and that there was going to be 1 victim under the age of 13.
That was the plea colloquy, yes. I can't get around what was
I
said
know, so
in
you
court.
understand our struggle on this side of
You
the
know,
bench,
you know,
right? I mean,
As with almost every NOLO or guilty plea appeal, there is some buyer's remorse, yes. And I think that just academically, this record and this case is a very good case to have some control over this not happening, where the state police find facts and a person that pleads to the lowest level of sex offense is placed on the highest level of the Sex Offender Registration Act with all of its punitive aspects.
All right, well, I think we understand the argument, and let's hear from the prosecutor, and you'll have a couple minutes for rebuttal.
Thank you very much.
thank you.
Good morning, Audra Blodgett, Kent County Prosecutor's Office. This court is correct that this case is procedurally complicated. And again, as stated in my supplemental brief. I apologize for making it more complicated with my mistake on the victim in my intermediate brief. I would also flag my argument that SORA is not punishment is no longer a good argument.
Probably
after
not.
The Supreme Court did not adopt my reasoning, instead finding in Cardas that it is punishment. So that section of my brief is also I'm no longer relying on. So in recognition of this, I would just agree with Judge Murray that in order to find ex post facto, we'd have to be arguing or finding that 2021 SORA is more punitive overall. Not that it has maybe one or two things that are more punitive, some things that are not, but that as a statutory scheme, it is more punitive. Overall, I don't think that that has been established in defendant's briefing, and it is his burden in that respect. Also, this court in Lyman found that there's fewer restraints imposed in 2011 SORA or in 2021 SORA than in 2011 SORA.
That was in Lyman?
Yes, Lyman and cited in my brief, it says, the court indicated in Lyman that although the restraints imposed by 2021 SORA are excessive, they were fewer than in 2011 SORA. And that was an analysis of a case that was ultimately granted by the Supreme Court as well.
That's still, it's still in front of the Supreme Court?
I believe Lyman came out of the Supreme Court finding that SORA was
But
not being applied.
what you just referenced though, was that from the Supreme Court or from our court?
That is in the Supreme Court in Cardas.
About the 2021 or fewer restrictions in the 2011?
Yes, and I'll pull it out, but because they were also tasked with the tier, an argument that a tier 3 offense was cruel and unusual as applied to CSC offenses. So
That was out of Cardas?
yes, looks like they're citing
Okay.
Lyman in there. And then to Judge Redford's points on cruel and unusual, it is defendant's burden to show grossly disproportionate. That is the standard for cruel and unusual. The Supreme Court and the legislature agree that CSC 4s, when performed against minors under the age of 13, are among the gravest of crimes. So I would argue that it is an appropriate punishment for that offense. And then as applied to defendant in particular, he was a family friend, took advantage of his position to isolate and grope a 11-year-old child. While in this case, he was charged with offenses against 2 other victims, and while on bond committed another offense, to which he pled guilty against a 4th victim. I think that is more than enough evidence of his risk of recidivism. So I would urge this court to consider that when considering the grossly disproportionate argument of defense counsel. Lastly, as to this court's points on judicially found facts for the kind of apprendi argument raised by opposing counsel, whether you find that this argument was waived by no contest plea because he admitted he knew he was a tier 3 offender, that was factored into kind of the deal he received from the prosecutor, or if you find that the police report as admitted as the factual basis did outline ages, and that removed it from a judicially found fact to just a fact admitted by defendant. Yes, this victim was 11 years old and I was in my 30s. I think those are both avenues available to this court to decide that issue of upholding his SORA sentence.
Okay. Any other questions?
I don't have any.
All right, thank you. Any rebuttal?
I asked that this court apply the same ex post facto reasoning that was applied in the Betts case that found that SORA constituted ex post facto punishment. And as for the difference between 2011 SORA and 2021, I think the main burden that 2011 had was the exclusion zones, and those were removed. Those were removed.
1,000.
And so that's
He needed a GPS
and
on
so
your watch.
yeah, and so they were horrible. But they they applied to a specific niche category of people that lived, worked, or needed to go to these exclusion zones. In as much as I don't know whether Jonathan Shannon is living, working, or going to an exclusion zone, but assuming, for the sake of this argument, that he does not go to those places, he is not being impacted by the ameliorative effects of the 2021 amendments. However, he still is being impacted by the punitive enhancements to 2021 SORA in the form of an increased burden in reporting, in his public profile, his ability for people to track him and things of that nature. So for that reason, it's sort of an as applied ex post facto argument.
Okay.
Thank you.
Thank you, Mr. Peterson. Thank you, Ms. Blodgett.
Thank you both. The case is submitted. Item number 20, docket number 373569, Moore versus Progressive.
No. Yes. Yes, I do.
All right, I'm sorry for that. We have defense counsel, you're endorsed. Are you Mr. Manson? Okay, you are not endorsed according to our records. According to our records, you're not endorsed. Do you agree? Oh, okay, I just want to make sure.
Yes.
All right, thank you.
All right, good morning, Your Honors. Kaylin Piper on behalf of the City of Saginaw. We are the defendants appellees on this matter. I'm not going to belabor all of the issues here today and go through all of the medical. I understand that you're pretty well prepared on this issue.
You did a
So
persuasive brief
I appreciate
as
it.
the
Comprehensive.
appellee.
So I'm just here today to answer any questions that you might have in regard to this matter.
Any questions?
I don't. I thought both sides briefed it very well. Whenever I get these cases, I have back issues and I just think, oh, God, but I thought both sides did a super job on the brief. So thank you.
Every time I get one of these cases, I think that the No Fault Act will never be fixed where there's not litigation.
Correct.
Right.
It just
Oh my
is
gosh.
incredible. Anyway,
We had some yesterday on on a motorcycle and a young man was killed unfortunately. And it was, one policy had 250 and the decedent had unlimited on his motor vehicles. And, oh my gosh.
but you know, it's a problem. Oh, I'm sorry.
No, I
You know, it's a
remember when
problem.
it passed.
I'm from Metro Detroit area and, you know, on any highway, all they are lawyer billboards for car accidents.
Oh, yes.
Every television commercial during a sporting event is for, you know, call us if you got hit by a truck or a car, blah, blah. And yet the statute was created to reduce litigation.
No
It's
kidding,
like, what are we
right?
doing here? But anyway,
I suppose it keeps me in business.
yes, I know. It
So,
keeps a
No,
lot
it
of
does.
work.
It keeps a lot.
Yeah, my son does no fault
I think-
defense work,
I
so
think
I
we'd have a
keep him in
third less
business.
judges on the Court of Appeals.
Right, right.
If we went back to a traditional tort
I
system.
will say though, sometimes I wonder if I should have gone to medical school instead. You know,
Yes,
after
I know.
reviewing all the records and
Yeah.
things. So, all right. Thank you, Your Honors.
Yes, thank you for being here. Appreciate both of you
yes,
being here. Your
and
briefs
I-
are very
Sure.
good
Yeah.
and we have a
Thanks.
good grasp on the
Thank you.
case. Thank you very
Are
much.
you
Thank you.
from Saginaw Council?
I'm from Saginaw.
Oh, okay. You're,
Have a safe drive back.
Thank you.
okay.
Did you know Al
You too then.
Reimers? Al Reimers, who
Oh,
used,
yes.
he went to law school at Detroit Mercy, graduating with the presiding judge and my husband. So if you see Al, say hello. It is.
All right.
Thank you.
Yeah, thank you both. Have a safe drive home. Are you good to go with the last case? Okay.
The
All
one
right.
judge, number 23, we've got someone appearing for questions, just.
Oh, okay. All right. Yep. Item number 21, docket number 374-282, Thomas versus Thomas. And we have,
Ms. Hers.
yeah, Ms.
remote.
Herr is on remote. Okay. Good morning, you Ms. Herr?
I am, Your Honors. Good morning.
Morning. All right. Well, it's your client's appeal. We have plans counsel here as well, and you may proceed.
Thank you, Your Honor. May it please the court, Lori Herr for appellate Brad Thomas. We are here asking that you reverse the trial court's ruling when it declared joint legal, joint physical, and equal parenting time was appropriate in this case. Your Honors might recall that Brad Thomas was once before the Court of Appeals, and in an order dated February 22nd of 2024, this court ruled that Brad was in fact entitled to an evidentiary hearing on his long delayed custody motion, which was pending at the time of the judgment of divorce. And the court at that time had sua sponte entered that judgment of divorce while those motions were pending. Following the remand, the hearings at the trial court did occur, but we believe that the trial court failed to adhere to this court's remand requirements to consider, to weigh, and to determine the children's best interests in light of the fact that there was much delay because of the 2022 motion, which again was dismissed pursuant to the judgment of divorce.
Could you explain? I don't understand what you just said. The remand was to hold a best interest hearing, and a best interest hearing was held, correct?
It was held, yes.
And the trial court made findings under the best interest factors.
Not necessarily, no. So what the trial court did is when it started its remand hearings, it first took upon, there was some show cause hearings that seemed to happen in the interim when the case was pending in the Court of Appeals. So the court throughout these proceedings, throughout those hearings, and even in its decision and order, really seemed to not be appreciative that the case was back on remand before the trial court. And so, yes, I would say that there were hearings.
Trial court counsel, the trial court on multiple occasions and you said it in your briefs. I mean, it referenced the previous opinion of this court. I don't think any of the three of us were on it, but this court issued, the court talked about it. How can we come to the conclusion that the court didn't understand that it was a remand?
No, I believe the court understood, but the trial court certainly limited the amount of time that each party would have to present its case.
Right. Surprisingly, a trial court said you don't get to have a 2-week custody hearing. I mean, both sides were given, it was 3 full days of a trial court's docket. That is a substantial commitment on the part of the trial court as far as the one resource we can give is our time as trial court judicial officers.
It's probably better if you just address why you think the trial court erred in its findings as opposed to not complying with a remand order.
Sure, certainly. So if you read the transcript, I'm sure you guys have done that in regards to the trial court.
Hold on. The Intermediate Court of Appeals for the state of Michigan are not you guys.
Oh,
You guys, you can talk to and I say this to any lawyer that says it, I'm not picking on you. Every time a lawyer does this, I stop the proceeding, whether I'm PJ or not. It is this court, this tribunal, you judges, we're not you guys. There's a formality to this. We are the Intermediate Court of Appeals of Right of Decisions of Circuit Court. We handle 5,000 cases a year. We are not individually important, but the function of the court is important, and it is inappropriate for us to be ascribed with the moniker you guys. Please proceed.
I apologize, Your Honors. So in regards to what the trial court had done, if you read the transcript, specifically we believe that the trial court may be honed in on those best interest factors of MCL 722.23 A through L. And so what the trial court did in regards to its holdings, it did not find any specific evidence under those factors. It generalized its findings under those factors. So reading the order and opinion, you cannot figure out what factors the trial court relied upon. Certainly during example, MCL 722.23b, we understand is the capacity and the disposition of the parents involved to give the child love, affection, and guidance, and to continue the education and raising the child in a religion or creed, if any. But the trial court in this case merely indicated that there's love between the mom and the children and between the dad and the children, and so the parties are equal on this factor. But the court didn't go into all the analysis that was had in this case and all the evidence that was presented specifically. And if you look at MCL 722.23b, it's not just is there love, it's more than just an emotional factor. And so there is a capacity and disposition which needs to be judged to determine whether the parents have that capacity and disposition. In this case, we argued that there was no capacity or disposition of mom to provide guidance to the children. And we outlined that in our brief. And some of those examples of things include specifically that there was expert testimony from Cricket Alexander, who indicated that mom did not have the capacity and disposition, and mom did not have the capacity and disposition to put the children's needs first above her hatred for her ex. There was testimony in regarding to mom taking the oldest child to dad's home and throwing trash in his yard. There was evidence presented that when BMT, the next oldest son, was in counseling, mom would hijack those sessions and talk negatively about dad in front of the minor child. So there was a lot of evidence that was presented that the trial court did not allude to or did not indicate that it considered. The trial court also, when it came to evidence from 2022, which was our experts, Cricket Alexander and Dr. Kim Lee, the trial court said that that evidence was essentially old. And it wasn't old. The problem was because the case pended so long because the judgment of divorce was sua sponte dismissed. And so there's several factors. If you look, you really can't determine exactly what the trial court had assessed in each of those individual factors. There was more of generalizations.
Well, that was always something, counsel, that having a trial, having a family court docket, I mean, you can't possibly comment on everything. It's just not feasible. Does it mean that the judge didn't hear it or didn't consider it? Not necessarily, but findings were made. It sounds more like perhaps the findings that were made you take issue with, but the issue is there support on the record? If we armchair quarterback every family court judge on custody decisions when they've taken 3 days of court time, boy, we'll need even more judges at this level. I don't know. Maybe I'm more expressing an observation than a concern, but I mean, the judge can't possibly comment on everything, nor are they required to do that.
Thank you, Your Honor. Yes, and I know, and I do understand that. But in this order particularly, there wasn't reference to much record whatsoever or even what the judge specifically considered. So there was more of generalizations or maybe just one-line findings onto some of those factors of MCL 722.23. But there was no substantive, this is what the trial, there was no reference to even this is what the trial court considered or this is the testimony that the trial court considered in those findings, if you will.
Wasn't there something on the record, though, the dad's name is Brad, right? There was some moniker about don't tell Brad or we don't talk about Brad. And
yes.
Wasn't that acknowledged by the trial court?
Yes, Your Honor, that particular issue was a no Brad rule. So the children weren't allowed to talk about Brad, their father, and mom's home. That was acknowledged by the trial court. But the trial court in my review, I don't believe relied on any of the expert testimony. And there was a lot of testimony that was not refuted whatsoever by mom or any of mom's witnesses. I mean, we had principals come in and testify. We had the youth development program come in and testify, and all of them noticed that when the children were with mom, Cricket Alexander noticed that. Dr. Kim Lim recognized that when the children were with mom, there was chaos. There was not much control. She would laugh when they would curse. She would laugh when they would do something inappropriate. She would encourage them to talk bad about their father. All of those things were unrefuted in the record, Your Honor.
Okay.
And I just don't think when you read the judge's opinion and order that any of those were addressed or that he acknowledged any of those issues whatsoever. And it's hard to determine based on his order. I mean, his written order doesn't say whatsoever what the findings are, but on his verbal order, you can assess exactly what information, documentation, or exhibits that he relied upon in making his findings.
Okay, any other arguments you want to make, or?
That's all I have. Thank you.
Okay, you have plenty of time for rebuttal. Thank you.
Thank you.
May it please the court, George Parrott here on behalf of the appellee, Holly Thomas. Your Honors, applying, I guess, the logic of Thompson versus Thompson, which spoke to the notion that a temporary order can't be converted to a full custody order without an evidentiary hearing. This panel, a prior panel, I should say, directed by remand the matter back to the Van Buren County Circuit Court for purposes of consideration by way of evidentiary hearing on the issues of both child custody and parenting time, to assert that somehow this court's order was not followed by the Van Buren County Circuit Court, I think is an argument without any merit.
Probably right. So you want to just jump to that.
Well, thank you. I appreciate the court's recognition of that point.
We also recognize that on the other issues, it's a very deferential standard of review for the trial court's findings.
That's correct, Your Honor. Fletcher.
My question is, did the trial court make enough of a record to satisfy the appellate case law of the state of Michigan for us to make a reasoned and informed analysis and review?
I believe it did, Your Honor. As Judge Rick noted, family court judges are burdened with a volume of cases that is extraordinary, number one. Number two, are they obligated by the law to go through and analyze and say, well, Miss So-and-so said this, but if I really give good weight to that, but then Mr. So-and-so said this. And so if they got into that, we would have a backlog of family court cases that would never, ever get resolved. I found it interesting that counsel said, we can't discern from the record what the judge relied upon, but then they want to argue that somehow the judge ignored their evidence. Well, if the judge, you can't play it both ways. You can't say the judge didn't consider things and didn't enunciate or allocate a particular reasoning to a particular factor, but oh, by the way, it's clear that he completely disregarded this. It's not clear. The record in this matter is well developed. We had 4 days of hearings. We not only had 4 days of hearings, we had then beyond that an opportunity for counsel to prepare written pleadings to the court describing and reviewing every element of testimony that had gone into the matter. We then had not one in-camera interview with the minor children, but because of concerns regarding the impact of alleged bias or the influence of a particular parent upon the children before they came to speak with the judge said, okay, we're going to set up a situation where both of you bring them to my attention. and both set up appointments and both transport them to me, and I will interview them not once, but twice. This judge not,
In that regard, though, it brings up the question I wanted to ask, which
Sure.
was, which is that, he continued joint legal custody.
correct.
And there was, a fair amount of evidence that the two parties could not agree on, things like that. Yet the court continued with joint legal custody. Can you explain why that was a
Well,
use?
because parental disagreement, even persistent disagreement, doesn't dictate or preclude joint legal custody absent evidence that decision-making has truly been broken down. We refer to Daly versus Klonehammer, 291 Mishap at 667. Nielsen versus Nielsen, 163 Mishap, 430. Both parents testified to involvement in decision-making. No expert testimony indicated that joint custody had previously harmed the children in this instance. No finding of abuse, neglect, or unfitness. Dispute centered on counseling and appointments, not the incapacity of the particular parent to participate in those types of decisions. The court invited motion practice if disputes persisted. In other words, it provided a remedy for the parent in the event that there was a sense that his or her wishes were not being considered as part of a co-parenting arrangement. The children, as they got older and older, would have the ability to communicate directly with the parents regarding their desires and wishes, and the parents hopefully would be responsive to that. And both apparently have indicated a responsiveness to the oldest child, which was ironically an issue that the trial court made some comment upon. Michigan law doesn't require cooperative parents. It only requires capable parents.
Who can put aside their differences when it comes to issues of legal custody. So the
Right.
fact that you can't agree on a haircut, for example, not a basis to disrupt legal custody. If mom and dad are at the emergency room and a choice needs to be made for a child, as long as they can get to make that choice dually, we would not want to strip either parent of legal custody.
I agree, Your Honor. I don't practice in this area of law. I do distinctly a significant portion of my practice is trust and probate litigation, but I have held quite a few appellate cases in family law decisions. The one thing I bring to this argument is that I am a single father, divorced father of two, who had joint legal custody with my ex-wife. I shudder to think that I would not have been able to participate in decisions regarding those affecting my children, the significant decisions, if in fact, as Judge Rick pointed out, we're debating whether in fact I can or can't take my child for a haircut, or if in fact they have a sore throat, I can't take them to the pediatrician and have it diagnosed as strep. There's no indication in this record that either one of these parents, frankly, have divorced themselves from the reality that the best interests of the children mandate a base level of cooperation such that they can both act consistent with the best interests of these children.
And in fact, if I recall correctly, the trial court had these parents utilize our family wizard. Am I correct about that?
That's correct, Your Honor.
So that the judge can monitor, not personally, but friend of the court or someone can monitor to ensure that that communication is appropriate and taking place.
Well, correct, Your Honor. And in this instance, as I indicated previously, the judge made himself available to address issues that arise from time to time. There's no doubt, based on the record in this matter, that this is prior to the divorce judgment entering, and certainly post-judgment, has been a highly contentious bit of litigation between mother and father. Nobody's going to dispute that point. But on remand, this judge really took to heart what the circumstances were that the Court of Appeals directed him to reconsider and to evaluate and to clearly articulate, so that there was a structure moving forward that the parties could rely upon to advance the best interests of the children. The judges, and I can tell you this for near certainty. I mean, I've reviewed this record backwards and forward. The judge is not particularly concerned about the mother or the father. The judge in this instance is concerned about the children. The judge in this instance found, by way of additional information clear in the record, he found these children affable, fun, enjoyable to speak with in both times he met with them. He couldn't have been more impressed by the young people we're talking about here. And so, you know, he has indicated a willingness to entertain those issues that may arise that will be consistent with his obligation to make sure that their best interests are being looked after. This is, again, this is not an evidentiary record that is thin. This is one of the most developed custody records this court will see. We have the benefit of years of evaluation in this matter and 4 days of testimony directly focused on the requirements or the direction of this court. I would indicate in relation to, there was kind of some reference in the document that this in the appeal, excuse me, this judge was biased in some respect. And should be removed if this case were to remand it back down to, first of all, I'm not sure the issue's been preserved on appeal. And certainly to the extent that it could be raised at the Court of Appeals, the issue hasn't been clearly articulated or sufficiently articulated in the pleadings filed with this court. But the notion that somehow this judge was biased against this father based on the fact that he didn't give particular weight to the 3 or 4 year old testimony of a counselor who hadn't seen the kids in 3 years, or to, as referenced by counsel, Cricket Alexander, who hadn't seen them in 3 years, is not a credible argument. The argument in this matter, he admitted over our strenuous objection, admitted that the expert reports, and you know, it said they went to wait. Well, okay, I understand that. And there's nothing in the record to say he didn't consider them. Here's the other thing too, with respect to those psychiatric or the counseling reports or those kind of things. You know what the gravamen of what they articulate is these parents don't get along. Well, that's not exactly an epiphany. They don't. Divorced parents don't get along. They argue. And in fact, I would submit, it's kind of the nature of the beast. If they got along, maybe they wouldn't be divorced. So in this instance, the judge recognized that this is a highly contentious divorce. It went through factor after factor after factor. It articulated exactly what it found credible, what it found persuasive, and how this all played out. And it isn't as if the judge turned to my client and said, I find you in favor on factors A through D, and I find him in favor on factors E through F, and you guys are even on the rest. He went through every single one and said, you guys are equal on all of these. And it isn't because he didn't consider this or that he gave short shrift to the argument. It's because I think at the end of the day, He truly believed they were equal on all of these factors. Why? Because parenting custody decisions and parenting time decisions aren't about identifying the perfect parent. They're about identifying the best interests of the children and seeing that each parent hopefully can meet that objective. And in this particular instance, that's exactly what occurred. I'm available to answer any remaining
Your
questions.
questions?
No other question.
No, I don't think we have any. Thank you for your argument.
Thank you, Your Honor.
Ms. Herr, any rebuttal?
Yes, I'd like to start with the issue of joint legal custody. This court asked some questions in that regard. I will say that there was much record evidence. There was evidence that the children were taken to be tested for allergies at the pediatrician's office. Mom took the children without Brad's knowledge or consent. There was record evidence that there was 22 medical appointments that were made that the children attended. That Brad didn't have knowledge of. There was record evidence that the oldest child was allowed to disenroll in physical in-person school and go to online school, and that was via mom signing the paperwork without Brad's consent. There was record evidence that mom took the children to the pediatrician's office again because she thought the children might have ADHD, and I'm talking about the two middle boys at the time. She didn't notify Brad. Brad wasn't allowed to be involved in any of that information. The pediatrician's office, I believe, testified that they assumed that the parents were getting along and communicating, and mom was just there for the benefit of both parents. But Brad didn't have knowledge of those things. And so there is record evidence regarding, mom making unilateral decisions without consulting dad. And isn't that what joint legal custody is not supposed to do? And how do we know that the court even assessed joint legal custody? He kept joint legal custody, but there's no rationale in the record to suggest why he did so. He kind of lumped them all together, legal custody, physical custody, parenting time, but he didn't break them apart. In regards to the established custodial environment, there's no real evidence on why he found that both parties, had an established custodial environment. As I suggested in some of those factors, like MCL 722.23b, he just merely indicated that the parties both love these children and that factor was equal. There was no real analysis. I do practice in this area. And when I have a judge that's sitting, they usually go through and implement or at least say what other factors they considered. To Judge Rick's point, I understand they can't write 100 pages decisions. But looking at the decisions that he made, they're so general, it's hard to know. Brother counsel just indicated that there's nothing in the record to suggest the judge didn't consider some of the expert testimony. I would counter that, and that's the issue we're having, is there's nothing in the record to suggest that he did.
Can I interrupt you just for a moment? The other thought I had on this, though, and you as a very well-respected family law practitioner can appreciate, this judge keeps that file till the last child ages out. And will you admit or acknowledge that sometimes judges keep it short and don't accentuate on the negative because there's a long road ahead for this family and this court? I don't know that it's fair to tax this judge with he didn't do a deep enough dive. What if it was, I'm going to say what I say in hopes that this family can heal, because there's a lot of hurt feelings and a lot of just animosity between the parties. I just don't know that we can ascribe it that he wasn't paying close enough attention.
No, Your Honor, and I'm not suggesting that he was or he wasn't. I guess what I'm suggesting is that in the record, just as Brother Counsel had argued, there's nothing to suggest that certain evidence wasn't considered, and there's not enough in the record to suggest certain evidence was. And so that's where we come down to. If we have mere generalizations and we have a best interest factors that requires 3 or 4 subparts, and the judge only hits on one subpart or one liner and says, I find this factor equal, there's no way to determine what assessment was made for those specific factors? What findings did the judge use?
Well, it seems like an important opportunity then for the trial counsel to ask for clarification at the time of the pronouncement so that we're not second guessing.
Certainly, Your Honor, yes. Let me just look here. Yep. I think that's all I have to my points, Your Honors.
Okay,
Thank you.
well, thank you both.
Thank you.
For your briefs and your argument, and case is submitted. We'll get the decision out as soon as we can.
Thanks for the work you do.
Thank you.
Have a good rest of the day. Item number 22, docket number 371098. In Ray CD minor is submitted on the briefs. Item number 23, docket number 366132, People versus Davis. Mr. Eggert was allowed to appear for questions or, for questions. He's not here.
Is he online? He's not on.
And so that case is submitted. Item number 24, docket number 378344, in Ray Wenzel minor, submitted on the briefs. Item number 25, docket number 373895, in Ray Soka estate, is submitted on the briefs. And that concludes. Thanks, Paul.
Thank you.